Welcome to AYV Television on Channel 33 with a broadcast live from our studios. Natawa Il na Fritong. We same way so day online at www.ayvnews.com and we stream live now Facebook page Africa Young Voices Media Empire. And so I welcome to the program Hot Seat, the program where they bring people for talk about things where they happen at the country. We always can try to talk to people in a public service, people with the the judiciary, parliament, government, politicians, civil society, the media as well, waiting at the role where everybody they play for make this country go before. Inside today's program, where they can look at the judiciary, now one important arm of government where everybody believes need for be very independent and then for dispense justice in a timely manner and ensure people get access to to the judiciary as well right across the country. So they can look at them work. As recent times we don't hear from the EU elections observer mission, the follow-up team will come, then findings and then the reports would have been due. As well, we don't see how the MCC scorecard been rates the judiciary very well. So they can look at the issues and the inside the judiciary. But as always, I welcome with viewers them across the country and across the world. Mina Amadulamgana Ba, and as I can say, we all want salon for better. And most of we, now we sabi as country. We know to sim them. We know to dual citizen. We not get other side for go in case anything happen. So we can appreciate the contributions on our Facebook page, and as always, we appeal that we do them responsibly and be very civil. We all get right for disagree. You know, it's part of the democratic process. We all not go agree by everything on issues that they discuss or issues that they happen at the country, but we can disagree respectfully. Let me not abuse nobody. Make your point. Definitely, we can read them points and then can help you and form part of the issues that they discuss in this program. So now welcome and enjoy our time as we can talk about the judiciary. I get the pleasure for welcome me guest them. I get Elkas Sano, when the communications director from the Judiciary of Sierra Leone. Hello, Elkas.
Happy for the Fambulan.
This is a pleasure having you. I also get with me lawyer Rashid Dumboya from Legal Link, a human rights lawyer. He don't serve the Human Rights Commission of Sierra Leone, and as somebody where they write and talk about social justice, especially the Judiciary of Sierra Leone and access to justice. Welcome, lawyer Rashid.
I'm glad for the art today.
These are my two guests where they can look at the judiciary. But I want to start with you, Elkas. In recent time, since you take up this job as communications person for the Judiciary of Sierra Leone, a lot of things when they happen with the judiciary, they come out. Is it that there is more awareness about, the things the way they happen at the judiciary and things the way not for happen, where they happen, we make people, they make informed decision about the judiciary not doing well. Case in point is say the EU follow-up election follow-up mission, then reports, we talk about the independence of the judiciary.
Yes, when I assume this position, like you rightly say, judging from my background as a practicing journalist and somebody we don't go into development communications, I say the judiciary gets a very important role when you talk about consolidating with democratic credentials as a state or as a nation. And one key vehicle we use for transmit those gains, transmit the functions of the judiciary as provided for by law na the media. Because I know the role where the media can play in terms of building the perception of the people, changing the perception of the people, setting the agenda for a national debate. Now that makes us say the judiciary not be able to function in this 21st century without the media as a partner. Why make us say so? And because we recognize the role where the media they play for help we for take the judiciary very close to the people that's not the focus of the current Chief Justice, His Lordship, Justice Desmond Babatunde Edwards. Over the years, when me the practice as a journalist, many people they blame the judiciary either for the right or the wrong reason. Nine, I do a communication strategy. That communication strategy, I able make sure say the media for able help for tell we story in as much as we tell we story. Why make I do that? Because at time me communication strategy to the vision of the Honorable Chief Justice. Waiting at that, I just believe say this 21st century judiciary, the judiciary for open up, and not only opening up. I believe say the judiciary for be transparent and accountable to the people because the judiciary serve the people of this country.
Is it about opening up or doing PR or propaganda or ensuring that people understand what is happening with the judiciary and how people will get access to the judiciary itself and get trust in the system? Because there have been reports where they show say even if you do vox pop, we don't do voxes where people and tell you say they don't believe in the judiciary.
Lamrana, family where they listen. I want digress just a minute. If you go to the Truth and Reconciliation report, the TRC report hugely blame the judiciary as one of the causes, that is, either people do not get justice or selective justice or otherwise for the decade civil war where we've been get, then blame the judiciary. But if you look at that time when they do the report, the Truth and Reconciliation report, how many magistrates have been getting at this country here? How many judges? Then you look at from the Truth and Reconciliation report, the recommendations then where they make. One, then for able to make sure say justice, affordability, accessibility, then expeditious trials. Then quite apart from that, we for able to make sure say we able magistrates, judges them, then they now places them where people in the able access justice as a point of contact. Now, that years where Truth and Reconciliation be make their report and the recommendation. If you don't say judiciary don't go to a lot of reforms, a lot of sustainable reforms. One of those reforms now that the judiciary don't open up now. Over the years, you go agree with me, say people don't even know whether waiting they happen at the judiciary.
Okay.
Apart from not knowing waiting they happen at the judiciary, people don't even know the functions of the judiciary.
Okay.
And because they don't know unto this moment, they don't know the functions of the judiciary, waiting they happen. Then they misinform the public on waiting they happen. For example, if police they investigate a matter or matter don't start from they don't go for an indictment at the DPP's office. When that matter not come up it, whether then they blame, then they say then they blame the judiciary. When police something wrong, then they say now the judiciary.
But when people get matter back it delayed, now the judiciary then they blame.
Now this they say. Because
it's about trust. It's about trust in the judiciary. It's not about the judiciary they get for nothing bad name, but the judiciary itself gets a role for play. You go agree say there are matters, matters that we don't do na court for a very long time where they delay people and get for work they can and then they get judgment.
Now this are the say. Now, because also when we discuss to Sierra Leoneans them, we really need to be honest to we conscience and able to make sure say those concerns we able to carry and go to the doing board and profile recommendations them so that we judiciary will become an enviable institution, not only within the sub-region but Africa.
Okay.
In particular. Now, when you talk about say cases then they delay, cases then people and the enable get access to justice, all those things. When we look, 2018, there was management and functional review when they do about the judiciary. At that time, the number of judges per a judicial officer or a judge is over 100,000 at that time. Africa ratio now about 6,000. From 2018 to now, the Honorable Chief Justice therefore make sure say he see the need for able employ or recruit magistrates and judges them. With all where we recruit magistrates and judges them, there's still not enough. But the number dropped down from over 100,000 to a judicial officer, to a judge, past over 100,000 Sierra Leonean to a judge, it reduced to around 90. So even though it don't reduce, it don't even reach the African statistics where forbid to a judge.
Meaning
so
access to justice is still a challenge.
It's still a challenge because you look at that time when they do with census, we been get 7 million population, even though it don't move from that now, because from that time when they do people and don't the 18 years or more, so they don't born other things there. You understand? From that time to now, you find out say today, for the very first time in the history of this country, magistrates in the places where they not did. Then we get judges them aside where judges not ever they exist. With all those development, but at the end of the day, you they find out say also one judge, for example, Judge A, they get more than 250 cases before him. We couple with the limited number of judges or magistrates with the growing number of people, population as alone, that also they pose a huge challenge. Another challenge also, now that justice everywhere, now the world, justice is expensive. Now, the judiciary not get that money. Judiciary want to do more.
But we not get the money.
We not get the money.
Before I can talk
more than waiting we feel say we able to do, for able make sure say we achieve we mandate as provided for by law.
So in your estimation, when I don't do more, much has been achieved.
We don't do more. Now that make if you find out the kind and stand innovation where the Honorable Chief Justice don't get, and commendation where the judiciary don't get now, it not ever happened before. In terms of indexes, they don't play. In fact, some index then they with rating in terms of rule of law, world justice report, they not be even consider salon judiciary.
So now they rate Shalom.
Exactly.
That
means when I rate you, it means progress don't they happen. Because then cognizance or recognize the good things where they happen at Sierra Leone.
Lawyer Rashid, you know, human rights, professional as well, activist, and somebody who is an officer of the judiciary of Sierra Leone. You agree, say there's been progress, and what's been happening today, know they happen now, it's unprecedented?
Well, first of all, I really appreciate when you invite me to this leading program, hot seat. I don't know this program so much, so I'm happy to be in the hot seat with my friend here, El Cas. Of course, the CAS is doing work. Naina is a spokesperson in a way for the judiciary. But as an officer, you correctly mentioned of the justice system, they are for do justice to this topic and for call things as they are. No doubt, we not go say nothing don't happen in the era of the current Chief Justice. That will be an unfair assessment. We don't see some good steps that we don't take. For example, we don't introduce some new courts. Where really they make a lot of impact in the justice system, the corruption courts, the NACIT courts, and the sexual offenses model court. These are unique courts that are making a lot of progress in the country in terms of access to justice and even justice for these victims. And then, of course, with the issue of expansion, access to justice, like you rightly say, there are many new, courts in many areas that never existed before, so we must give kudos to Dandy. And of course, the equipment of also new magistrates them and judges there as well. They don't increase the numbers, which is good. And of course, we don't see also some beautification and some kind of administration set up. For the very first time, we see a division of the inferior courts and the superior courts. So now you need to see the magic court again, Chaka Stephen Street, and get them separate place where they meet in the holding proceedings. It's very nice because in a way the courts now Chaka Stephen Street jam packed.
Okay.
In them they create a lot of problems. So sanity, yes, sanity don't come back, and a beautification system, facelift of some offices, you know, AC then they now with the system mic system, which is good. You know, but then right now, me as an activist and also a human rights person, we don't travel internationally, don't look at international systems and judiciaries. Me, they look beyond just all of that and go to what I call the wheels of justice. All right, so it's not enough to have the men, do the expansion, you know. We must get to the wheels of justice. How the wheels of justice they turn. Because at the end of the day, they assessment, the real assessment. Because if you get the man, you get the building, you get everything, but then
but you need you need them to for ensure say you able to provide access, you able to provide quality service delivery as well.
Yeah, so we praise that. That's what I've acknowledged. But then if the challenge on the wheels of justice is still the clogs, you know, the clogs are still there.
What's the challenge?
Okay, so this is exactly where I really wanted you to go with me today. Now, for example, the judiciary still get challenged on the issue of political interference, manipulation, and control. It's one of the biggest challenges we don't affect the judiciary in time past and even now. All right, and I think
political interference.
Yes. And first we go blame them, but then we don't go blame them back much because the structural things then still tie the judiciary for make them become vulnerable to political manipulation. For example, I'll give you an example. The president appoints the chief justice and judges in our jurisdiction. And then one big room avenue for politics for coincide. All right. So we don't talk severally in many meetings and say we get for move beyond this. You know, Kenya may all get similar system like we, South Africa, but essentially they all decide say no. How do we insulate the judiciary and enhance its independence and impartiality? Let's start first with the way the men are recruited into that body. That's when they begin their debate. So let's start first with the way. So for example, in South Africa now, it's called for applications rather than appointments from the president. So you see, now one way and the way they help them. And make you see today, the Constitutional Court go order Zuma in lock one, nobody no shake. Zuma no get mind for Chris because he go one candy. Because the court is super empowered.
There is independence.
It starts from the recruitment. All right, so there it's called for applications, and people have to be openly interviewed. All right, the public is also participating in the interview. So your entire CV, your resume, your experience is exposed. So then we'll tell you how this person also beat this person, and you get to the seat, you know, without much of the president's interference. So somebody will have to argue now, say, well, perhaps they are making system still allow for presidential appointments.
Yeah.
All right. So make a response to the argument that in America, we can trust the Congress to serve as an effective checker. Is that the case for Sierra Leone? I would say a big no. We now know what is happening in Parliament. Every day they approve people without much scrutiny. So the system in America is one that can be trusted. For letting one person pass through, you take how many days or weeks, you see the scrutiny, public, you know, checkmating, and by the time you know, all things will you they expose. All right, that's how we have a sober Congress that can serve as a check on the presidential powers. That's not the same with our situation in Africa. That's why we have to adjust our system with waiting fit we.
But so Rashid, you don't be a presidential appointee. You don't work, and to some extent, you were able to uphold what you think is a credibility and your level of independence. That doesn't mean if the president has the power. But if you are appointed, it means you have a role to play. It doesn't mean you should side with the president. The Constitution doesn't say so.
Yes.
It gives the president the power to appoint.
Yes.
But the institution for being independent.
Yes. So here is the unique thing about the Human Rights Commission have. It's not really the president that appoints commissioners of the Human Rights Commission. And I think that's the model I want to even recommend for the judiciary. So these people are first, they apply first to the AG, and then there is an interview. As a call for application, there's an interview, and then There's a scrutiny from the public. All right. So, and the best 5 out of the 7 is sent to the president to choose among 5 of them.
Yes, and the president, that is what I'm saying.
Yeah,
it comes back to the president. The Constitution gives the president the power.
So here is the difference. The first choice is not the president.
Yeah,
no, it's different.
That is on that. I understand. But what I'm saying is,
that is the catch.
No, the point I'm making is, it comes back to the president.
Yes.
He makes the choice and decides.
Yes.
Until he decides, if the president says no, even if you're not the right choice, and he thinks, no, this person is not going to serve in this position, you're not going to serve.
So let me show you the difference. There's a difference there. It's different when the president wakes up one morning and says, I want Lambrana. And I'm coming. And it's different when Lambrana first goes through a process of call for application, vetting, and then eventually if Lambrana succeeds. No, I'm coming. Hold on. Just give me a minute. And if Lambrana succeeds, all right, to come before him, he confirms. It's different. All right, and then now Parliament approves.
The names are sent to the president. But what you at the time for say, the point I'm trying to make is about the powers of the president. It still shows how powerful the president is, how the Constitution gives the power.
Yes.
But the point I'm making is deciding to be independent and ensuring that an institution is independent. The Constitution doesn't say if the president appoints you for side with the president. You for be independent.
Yes.
So how do we get to that point? Even if the president appoints you, we've seen people who are appointed by the president, but then believe it waiting them for stand for, and they stand for it.
Yes. So you're making a very good point. So it's also about integrity of the person. But then how do we? So the question is, and this is until
that's changed. So, how do we say because now the president they appoint the Chief Justice, the judiciary is not independent?
Yeah. So what is clear from research is that when you have a systemic flaw in recruitment, you make the institution more weaker to be able to challenge the executive arm of government. That's what we are saying. So we're not saying there are not men who can challenge, who can take stand on integrity. We're saying let the system should not enhance the weakness of the institution. So how do we insulate the institution in terms of its recruitment to make it more emboldened? There could be people who can still go through call for application and still mortgage, we know. But then if you have a system, that's why Obama said, let's Africa work on strong institutions. All right? Because he knows that if our institutions are weak, then it becomes so easy for them to be manipulated and controlled by the executive arm. So now how do we do? So in the recruitment itself, we have to start there. Let's have call for applications
until we have a constitutional review.
Yeah, but we don't. Yes, that's one way.
Yes.
But then we can also have internal checks and controls
but
in
again,
the interim.
But again, the point is, I just watch at the MCC scorecard.
Yes.
The judiciary is highly rated.
Let me be quick too.
But I'm saying,
let me be quick too.
You don't highlight some of the achievements and some of the good things that will happen. Hasn't there been, steady progress? Say these are things we can build on for move forward. The judiciary don't show say we can change things which waiting and they do.
Yeah. So but then let me be quick. You see, when I saw the president from the judiciary, the Chief Justice is my man, and I respect him so much. But I was beginning to ask some questions. How can the judiciary take the praise on this issue? I was being to ask the question, how? Because it's a rule of law indicator, having so many sub-indicators.
Let me rule of law as well. I don't
that is why I want to go, because I cannot understand one institution taking that praise. Rule of law, it's a principle, all right? It's a corpus equality for the law, recognition of fundamental human rights. It's talking about also supremacy of the law. So I don't understand how one institution is trying to take that praise. I don't understand that. Because in my view, it goes beyond just the judiciary. It's a state of affairs. It has to do with many institutions complying with the law, due process. It's also about respecting fundamental human rights. The police here is key here. All right, so it's a status quo that is being assessed. Okay, clear court, the judiciary may have some bite in it, but it's not really I mean, a possibility for the
So the
of
judiciary not to take place.
No, I'm not saying that, but singularly, I think I have a problem with that because it's a status quo they are looking at. Rule of law, it has to do with fundamental human rights, respect for fundamental human rights, equality before the law. You know, the police is always having a problem with that. So the extent to which the police, at the very least, is being seen to respect human rights when they arrest people, you know, giving them the privilege to have lawyers, representing them, also charging them to court and allowing due process. The court has a part of it, but they cannot now, I mean, come clear and say, okay, this is fine for us.
I mean, as an officer of the judiciary, the justice sector in the country, in your own assessment, you know, in the 3 years down the line now, access to justice, dispensation of justice, do you think we've progressed as a nation?
Yeah, I think we have made some progress in access, but we're still struggling with the issue of dispensing justice, one, and also in a timely manner. All right, we still have a lot of cases hanging there, all right, and that are still not been decided by the justice system. Judgments are delayed, all right. The other day we even recommended that at the very least, judgment should be timed. The Constitution times judgment and let the Chief Justice enforce that by even withholding salaries so that judges will deliver on time as required by the constitutional mandate. All right, and then we also believe there is also the problem of, and even the Longan system is also affecting the justice system. We still take notes by hand.
Not digital.
All right, so a lot of these issues are systemic. It's not that the men are not there, but the system is not really moving as it should to meet up to the challenge. So in the area of access, I think I'll give a pass in terms of the new court structures and the system that have been established. But in the area of dispensing justice, and that's what the EU report really needs.
Yes, now we can talk about the EU reports now. And I just want to ask Elkas that, you know, the issue of dispensation of justice and the EU report, actually, their line was justice delayed, justice denied. They're talking about how, you know, waiting I should just talk about, you know, the dispensation of justice. How people and they get trust in the system and believe, say, if I go court, I not go, they come there over 1 year, they wait for late and give judgments to make case. These are things we people and even ordinary people think. The EU reports, I see, una don't reply to them. Una say, you know, una lost respect for the EU that now una say and all that. But the content of it, the issue of dispensation of justice, that's something where I think say na legitimate concern and something that you should look into.
Yes, but it would be a disservice to my conscience and the people of this country if you not allow me for
you definitely get the time. You can respond to what you are respond to and move on to the question I ask you.
Exactly. Rashid talk about South Africa or other places. If you watch Sierra Leone, one of the most bloody civil wars will happen at the history of the world. It happened in Salon. You understand? Where it reverse all the gains, all the progress we make as a nation with a backward, where you know they compare the magnitude of that destruction will happen to them other countries them we don't advance. What means say it's similar to when you build a house. You know they go roof a house where you know build on the foundation. You build on the foundation, you make sure say the structures are there before you roof the house. Similarly, it's shameful, but my tell family made they hear this, including Rashid. When the Honorable Chief Justice, His Lord Chief Justice Desmond Babatunde Edwards take over, family, I want to tell una say now only 2 graduates, the whole judiciary of Sierra Leone, now only 2 university graduates that judiciary of Sierra Leone been get.
The administrative wing of the judiciary.
Exactly. Now only 2 graduates.
Okay.
Then apart from that, 1 grand person, all the power now I will get to himself when I've been the master and registrar. There was nothing like court operations. There was nothing like a whole judiciary. There was nothing like human resource person. Now the whole judiciary. You understand? Now, we not be even get procurement person, procurement manager. This were administrative problems where they hinder the effective and efficient administration of justice,
Okay.
the effective and efficient functioning of the judiciary as
But
provided.
Rashid don't commend that. He
No,
don't commend. But Rashid don't commend una for that.
Yes, but
he don't say all lentin and they say nothing.
You know why make I need for say this? That they tell you say, if you not put them thing in place,
Yeah, but
you know the wheels of justice.
Yeah.
There is no way the wheels of justice, not to robots, then the thunder wheels of justice. Not to robots, them at
They
all.
don't commend una for that.
Yeah, so,
say there's been progress in the administrative aspects of it.
Therefore, it's far-fetched for me you say waiting South Africa don't achieve. You understand? Over the years, with a steady progress, more we can achieve them in just 3 years or in just 5 years. That's the truth. And that aside, if you look at those reforms where don't happen internally, if you go to the judiciary, now be like it been just synonymous to any Congo market. Everyone the way they talk down over the years, where people and they go sell markets at the judiciary. Everywhere. North, if you go now inside holding centers for this people away in the pool na correctional center. That judiciary was in the smell. Judges them or magistrates the way they can't work. They place AC no day now under swear to judge them or magistrates them the right to judgment in this 21st century. Can you imagine that? If all those things we don't say this because we also educate the people and make them understand from the ashes where we take or the model where the judiciary where we don't move from. You understand?
You've been to establish that. Rashid don't commend the judiciary for that. He don't highlight them. Say the edifice don't change. The get AC now and progress don't happen. We're talking about the issue about.
I also talk about the independence of the.
Exactly. These are the issues where I want to look at the independence of the. Yes, the independence of the institution.
Exactly.
And dispensation of justice.
The judiciary is a creature of the Sierra Leone Constitution.
Yeah.
Section 121, subsection 3, they tell you what say when the judiciary, in the exercise of the judicial function or with judicial function, the judiciary not subject, not answerable to any institution or anybody whatsoever, only to the Sierra Leone Constitution or laws were legislated by Parliament. You understand? Now, Lawyer Rashid make reference to the Human Rights Commission. If you look at section 35, section 35, 1 and 2 of the Sierra Leone Constitution, it tell you about the appointment of the Honorable Chief Justice. It tell you about the appointment of judges, where they tell you say the Judicial and Legal Service Commission. You understand? The president in consultation with the Judicial and Legal Service Commission. The way means say the same thing way they tell you about Judicial and Legal Service Commission. The same process. Now not to me talk now waiting the Salon Constitution say. Now then they make the recommendation to the president. You understand? In terms of even recruitment of judicial officers or judges, now the Judicial and Legal Service Commission, now their own responsibility, that's squarely. That's now a constitutional provision where possibly even the tamper with. Moving forward, now that there are still challenges, I must admit that. But
challenges on the independence of the judiciary. Challenges on what?
In
dispensation
the
of justice.
In administration of we function. For carry out we day-to-day activities as provided for by law. We get challenges them. In as much as we get those challenges.
Are you talking about interference in the judicial system? Your independence?
Not to interference. If there was like people in the talk about perception. If you talk ask the one that talks the judicial independence or interference, political interference, you go ask now, including Lawyer Rashid. Make a point one particular case where he know of where the presidents don't interfere. where you don't tell you, where you don't say that particular matter.
But those
No,
are
they
things
can.
when they come public, now there's a perception. It's about
exactly.
how
so
we
therefore,
do.
therefore, we own responsibility now for demystify that perception, for able to build and repose confidence. People who have been the whole that kind of perception, it's a myth.
Okay.
And therefore, I want to assure me, brother, say, but bring cases them, landmark cases them. Samura Kamara, the petitioner, now a presidential candidate of the main opposition now, All People's Congress. He win in case that they tell you, say, that's now for able to demonstrate the very fact, say, indeed the judiciary independent. Okay. Then I just one. Kane Yom Keller, he was everywhere. They commend the judiciary. They said, this is what we have been clamoring for. For see the independence of the judiciary in executing then effective and efficient administration, especially when it comes to for discharge the functions as provided for by law.
Okay.
That's not just another one. Kane Yom Keller, another just one. I don't want to go into other cases them where you know, but you understand.
But the opposition would tell you, say that 10 of the members of parliament, lost in case them, and they were thrown out of
you
parliament.
Agree with me, I say, or maybe if you don't listen, see the Tunis, where now the acting publicity secretary of the main opposition, All People's Congress, been there on 98. He say the judiciary, we want to commend the current administration provided by the current Chief Justice. Why? The judiciary don't help for build the democracy of the democratic credentials of the APC. Okay. The judiciary don't able to make sure, say, bring sanity in the APC in terms of democratic reforms. Okay. That's now for tell you the role of judiciary. It's not only about for go no more judiciary for go convict. Not only conviction, now the function of the court. Okay. You understand? For able help for able build on a democratic credentials. Now a very good
can we look at the issue where Rashid raised when the dispensation of justice? Let's forget about the political class, our people within our politics, they are now the high-level case and they were always killed in the media. But there are individuals, Sierra Leoneans, who still think, they don't have trust in the judiciary.
Lamrana, say they don't get trust in the judiciary. Yeah. Now, if you go na we website, man not even because man not call the statistics offhand. If you go na Sierra Leone na the judiciary website, okay, from the assignment of cases, we now, because we want for be open up, we want for change the perception of the people by restoring trust and confidence in what we do. When the Honorable Chief Justice in the assigned case, one day happen, okay, as he assign the case, we make sure he workload them. Okay. This person, but at the camp, that now is about. Yeah, no, tell you how this is important. And they tell you on the administration of justice, because you know why? So that we able benchmark we achievements when it comes to delivery of justice. So, for doing expeditiously.
So are you agreeing that with Solo Rashid that they are challenged in the dispensation of justice, the delay in cases, even say the Chief Justice gets power for even withhold salaries for ensure say people then do their work. Are you agreeing with him on
Lamrana, in terms of challenges, I highlight challenge, the challenges the more we get. Must state this verbatim, the exact figure. As it is now, I've been telling you, say, when we take over 2018, okay, that management and functional review where they do, now be over 100,000. Okay. Now the current statistics for per a judge or judicial officer, now 93,317 citizens, one citizen to a judge. More be honest. How many judge, all put together, judges, magistrates, what you put together, will not even reach 100. Okay. Now this one whole country, a population of almost 8 million. Okay. That's the one. When you watch at with judicial system, Lawyer Rashid go agree with me, say, a litigant driven. Then you look at, we lost them. There is need for more we also review some of them lost them. For example, if you watch at the Supreme Court rules, the Court of Appeal rules, now in the 80s,
Okay.
Rashid go agree with me. There is need for review some of them laws there, because
Okay.
it also there. You know why I say this? If you look at the fast-tracked commercial in court rules, I think 2020, it they tell you say when you want come before the court, you they do what you call front loading, where you don't file in witness statement, all them thing, you put all thing there. Then at the end of the day, we get the ADR system or whatsoever. But now, with this one where we get, guess waiting. When you go, the judge no gets that authority for take the judge no they tell you say where you want take adjournment, you the lawyer.
Okay.
The judge know they prevent you. Some case then they inside 1 month, the lawyers they take more than 10 adjournments inside 1 month.
Okay.
And this has some concerns them were also important, because the attitude of the lawyers them
So
also
the problem not only the judges say no more.
No, not to only itself no than they not to
Okay.
not to what I mean by that now that in as much as we not get enough judges them, enough magistrates across the country, but also the judges them they do well for able to make sure say more will deliver on with mandate. For example, if one judge gets 250 cases before him, then another case come before him. He get for write judgment, he get for do research. All those things, it will go through the file for research, for able to make sure say it get in fact them correct when it deliver in judgment. Because the court, not a court of public opinion, now a court of law. And even when they deliver judgment, it is based on law. It get for do research. So waiting with they say, we need money. The judiciary need money. When we go recently now the budget, guess waiting. We go request for 40 billion.
Okay.
They not give we am.
So money no dey.
Exactly.
Nine are the challenge.
No, that are just part of the challenges
Okay.
that we get.
Hey, Lawyer Rashid, you know, it's El Kazi try for say with the progress they agree with the challenge, but it's not just them. You get lawyers them back way. Sometimes clients go get case, they don't even appear for defend them, and the judge get for adjourn the case, and all that they cause to the delay. So when I say when I officer them of the justice system, self gets a problem with that.
Yes, I think Sudan is something we will not run away from. There are many lawyers that way also know they help in terms of the way then they handle and do their cases. All right, but then it all comes back to the justice system, because they are the ones in control. So nothing stops the Chief Justice from having, you know, a practice direction, you know, or some kind of policy where they inform on adjournments. All right, so it makes a policy to all man them in the justice system. I mean, the judges and the magistrate that not beyond 1 week. All right,
Okay.
you know, adjournment. That could be that kind of understanding or that practice direction or that policy day from the judiciary in a bid for at least expedite, you know, justice, you know, delivery. So
Okay.
I mean, in good faith. So it comes back to the judiciary. You have to float out policies.
So for you, it's about
frameworks.
the leadership of the judiciary.
Yeah, well, so I blame first lawyers the way they do, because without the policy, we should also understand that we are part of enhancing speedy trials, and by the way we do our cases, and don't take unnecessary adjournments.
Okay.
But then that is just human nature is just like that. So how do we now, that's why you see, we will avoid putting things in place. We will open more room for things to happen that will affect the system. So let's have a policy framework, you know, directive that will now inform the benchers that no more adjournment beyond a week.
Okay.
All right, and then there should be clear-cut, you know, evidence warranting, you know, an adjournment to be taken.
Okay.
All right. For example, if I were a judge or a magistrate, you know, when a case is before me and a witness has testified, I will not allow the lawyer on the other side not to finish his cross-examination on that witness. All right? So it's all about also the benchers also having some internalized system, except
We go speedy.
As a lawyer, it goes back to the law, not to we they make law.
Okay.
He agree with me say, not to we they make the law. For example, if you go to the fast track commercial court, if they tell you say when you take adjournment within 70, not more than 72 hours, but then can come, they can
For
take
1 week.
not more than a week. Sometimes some even can attempt for doing more than 1 month. It will tell you say my clients they out of the jurisdiction.
Right, okay.
Especially another thing we can happen where people know way also, especially when you jointly charge. When you are jointly charged, one person there, the lawyer will tell you, say, no, this person is supposed for there, before I will come, I can cross-examine or whatsoever. They take advantage of the loopholes where the law gets. So many adjournments, so many all those things. You understand? So instead, no.
The council will take me turn.
No, I agree. So let's go also for review those laws also.
So eventually, who makes the decision? So lawyers will always make applications. That's why we have somebody there, the judge or the magistrate. He decides. So as they push onto me they stand and say again, well, let's go back to you people.
Okay.
Because eventually, lawyers will always make their decisions, their applications, as bogus as it is, as flimsy as it is. So, but the justice person they foresee whether in fact there is merit here to grant or not grant. If you say I want 2 weeks, I'll ask you why, for what? No, this trial should be speedily done. I'll just give you 3 days. I'll give you 4 days. So it's have to be approved by of course the magistrate as well. So, but then let me go to something more important. Beyond this, the EU report is very important.
Yes, now we can't talk about. I just want if you agree with waiting a case they say, because the public perception has been now the magistrates, now the judges, now then the delay case. It's not about even the lawyers.
No. I think I just said that also. Some lawyers also. Some lawyers also do that. But then, how do we circumvent it? It's not enough to say to be apportioning blames. We must have policies in place. You just talk about the law, but we have many practice directions that the chief justice have floated, many policies as well. So that can also be informed by a policy directive to his men, all right, to say, okay, no more adjournment beyond this period, especially for criminal cases, except there are circumvening and, exceptional circumstances that could warrant that extension. All right, that could be a policy.
Okay, we can talk about the EU reports now, the EU follow-up mission. Waiting and say, one thing we highlight, they mention, very important for look at now, that they say the 2019 High Court decision to declare the runner-up elected in 10 constituencies eroded the confidence in the judiciary. Unequivocal respect for the rule of law in election petitions is crucial for ensuring confidence in the electoral process. So the point is, we must forget other petition cases. If the EU will observe the election, say, that decision, they don't erode confidence in the judiciary. But the judiciary is saying, let me read a part of their press release, which says, the judiciary wishes to inform the EU that under the Constitution of Sierra Leone, Act number 6 of 1991, the judiciary is an independent organ as guaranteed by Section 120, which states that in the exercise of judicial functions, the judiciary shall be subject to only the Constitution or any other law, and shall not be subject to the control or direction of any other person or authority. The judiciary go ahead for say they not lost respect for the EU follow-up observer mission anyways. But as somebody I read on a point we want to make, 15 or so points we want to make why the judiciary for look at the recommendations or statements from the EU team. This back and forth, it seems, what does it mean for us? We get forget elections. Definitely the EU get for observe. They will make recommendation, but the issue of trust in the system.
Yes, so I mean, this is now one of the most unfortunate things that happen, especially in my country, where personally for me, I was not really happy at all. For see
happy about what?
The way it's not about just the judiciary, the way all the EMBs, election management bodies, they respond to a reliable and trusted partner. We mean so well for our election
but it wouldn't mean they always right.
Yes,
they can be challenged too.
So what we are appalled with is the manner and the response. All right, you have to have it right in your response. Now, most of what they say, in fact, in the report, nothing the way have been said long before by many people against these bodies. So there's no new thing that they have said actually. All right, they just reiterated established facts that have been contended by many people, including CSOs. All right. So there are no new findings in the EU report. And secondly, we are also not happy that the EU report is a balanced report.
In your own estimation.
It's not. It is a.
But the judiciary thinks otherwise.
It's a factual thing. The report. I read the report. Only my personal read the report. The report is there. The report praises the government on many things, and it highlights the challenges. When I saw reporting, never be written across the world, stresses challenges and recommendations. So nobody is talking about the good things that the report said. All right. They only farm and those they look at the few things then we highlight on challenges. Now, for example, and I was looking forward for see the judiciary or whoever write that press release there, because I know for the judiciary as a blanket.
But it's from the judiciary. It's from the communications.
Yes, I'm sure the communication or the master or whatever, somebody signed that press release.
Yeah. Now,
so whoever signed that press release, I'm the wait for see, because one of the strongest allegation the issue where is raised that of course the judgment against the MPs. Yes. And the EU quotes the law. There's a law on this issue. Section, I think 146(4) of the Public Elections Act, where say when an election has been void, a rerun shall be held. All right, clearly. Now, it just draw their attention, say, this issue, then at the law, and we not see any other situation who say at least justify this from happening. Watch this thing. So within the EU public saying like, let we watch what they do. Because then they get tendency for create distrust and problem down the line.
Let me go forward to read what they said.
That reply?
Yes.
You mean the judiciary?
The judiciary.
Yeah, let me the
judiciary said.
The reply.
Let me just start from this point. So while we accept section 146(4) of the Public Elections Act, number 4 of 2012, did say that where elections are declared void, you can order a rerun of the elections. At the same time, it is wrong to assume or convey to the public that this is the only remedy available. Thus, while there has been misplaced reliance on section 146(4) of the Public Elections Act of 2012, these provisions have to be interpreted in line with the provisions of the Constitution of Sierra Leone, Act number 6 of 1991, which as a constitution supersedes the provisions of section 146 of the Public Elections Act of 2012.
So nothing has been said by the judiciary there.
But then
there's nothing has been said. So, and that was the opportunity I believe they had to have said, okay, you are looking at this law. We have other sections, and here are the sections. There's nothing there. They're just saying, if you look at this law, look at the constitution as well. Whose section, whose part of the constitution you look at? So that was
they mention the Constitution of Sierra Leone Act number 6 of 1991.
That is the title of the constitution. It's not a section.
Okay.
So what we're saying that was the missed opportunity. So I read them. I said, but what did you try to say now? If you were contending that this provision not be misconstrued because other provision, show we have provisions in the constitution where perhaps overshadow that provision there. Then I'm one for C.
Okay.
So in their bid of responding to a genuine concern, they flipped. There was nothing that they were saying in their response because they did not quote any law. They said there are other things that you can watch, but what are the other things? Nothing was mentioned.
Okay.
All right. So what do they say? The response here, so not to the right response. You don't get good spirit.
Okay.
When we do things way wrong or way we miss some, as a judiciary, we can just say, all right, we have seen what you've said. We're going to look into it, and then we will get back to you.
But what is wrong? What is wrong for the judiciary to challenge the EU?
There's nothing wrong. There's nothing wrong in that. But what we are saying, if you're challenging it as a judiciary, let the facts be clear.
Okay.
But in challenging, let me just 1 minute. In challenging it now, the facts are not been laid. There's nothing that you showed us that contradicts 146(4). Now, so what the other thing that interests me, okay, it's like a program. The other thing that interests me is the quickness also of commending another report that makes you look good.
Okay.
Now nobody ask, because some people in the judiciary and some officials and even the state officials were saying, who did EU ask? We're not even to us whether they ask. Well, nobody is talking about who MCC asked. They're all jumping at it.
But the MCC clearly they show saying a World Bank and a third-party information and they take for doing report.
So this is the point. So let's stop questioning who and who they ask and what they saw, and then we are quick to embrace that report. But then when the EU say something we no look appeal to we get for challenge them and condemn them. So that two face day, I don't think.
Let me hear you from him. Now you write this you know, this response. How did you call it? Judiciary position on the findings of the EU team. You know, Lawyer Rashid now they say, you know, it was an opportunity for me to explain, you know, the interpretation of the law and what it means. You say when I miss the opportunity, do you agree with him?
Lawyer Rashid is not really honest to the people of this country. Yeah?
Okay.
You know
why you say so?
Fine. You know what I make I say, I just need to tell you the tricky part of lawyers. I say, you know, honest to the people of this country. Yeah? You know, say, when a matter come before a court, the court or the judge, they decide or they deliver in judgment based on the evidence we adduced before the court, supported by law. Instead go agree with me now. Now, I go also agree with me say, judicial precedent in itself now law. I go agree with me with that. In the reasoning of the judge, we deliver that judgment, or the judges, then feel say that moment, waiting and do, was correct, was right, in the reasoning. Okay. You understand? Because if you look at the Public Elections Act, where we say, not to enter the only remedy, section 146, subsection 4. Waiting tell you say, it tell you say, when they don't declare an election void, there should be a rerun. Now that's not the provision. But also, the Constitution will supersede the power of all other laws therein. They tell you say, section 75, section 75, they tell you, waiting at the requirement for being member of parliament.
Okay.
From section 75, 76, 77, 78. You understand? One of the requirements where the Constitution states for becoming a member of parliament, now that if you be a citizen of this great nation, if you be a Sierra Leonean, if you be of sound mind, it make the relevant, it set the relevant requirement. Now, one may could say now them wrongly misinterpret or convey a very wrong interpretation to the public. Now that, may bring a particular case, Timbo in case. Timbo in case, there was not declared void. So if you not declare Timbo in how they call them, void, the one where they declare void, there was a real one.
Okay.
The EU did not, the EU not state that. You go agree with me, say there was a rerun in one other, that one Josephine Jackson or whatsoever. There was a rerun. Because in the reasoning of the judge, it been first say there was need for a rerun.
Okay.
Now, if the Constitution don't tell you, say, these 9 are the requirements, including if you resign 12 months before even they present you as a candidate for becoming a member of parliament. In that situation, where section 78 of the Constitution, married them verbatim.
Okay.
Please allow me to read this position. Section 78, it tell you say, the High Court shall have jurisdiction to hear and determine any question, blah, 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 waiting at the questions then. A, 78(1)A, it tell you say, any person has been validly elected as a member of parliament.
Okay.
So meaning, if Lawyer Rashid don't petition me for on grounds that I not qualify for become member of parliament, you they come to the court for inquire whether in fact I was validly elected. Now waiting, not to me say, now waiting the Constitution say. So Timbo in your case, now that they say the allegations where they come with evidence say Timbo no resign or no retire 12 months
before the
election. So you see the case we're different, we're completely different. I want to come say this man because this is an opportunity.
Yes, we need for them fast because of time.
Okay, thank you very much. It means say, Lawyer Rashid na lecturer na Frobe College. Frobe College, they say before you go Frobe College, you forget 5 hours or O level. If you go, you don't do Frobe College, you don't do year 1, year 2, year 3, even year 3. Then the administration notice say you don't get 5 hours. It means say you don't get any business for coming to Frobe College because in the first place you don't violate waiting at the very University Act or whatsoever provision requirement where they said where they tell you say you forget 5 hours.
Okay.
Similarly, if the law don't tell you say you for resign 12 months, they don't resign. You don't already act in contravention of that particular provision where tell you say you for. It's not about whether the elections you win them or you don't win them.
So all the other cases, so all the other cases, not Timbo in scenario you give. So all the other cases were the same as Timbo in scenario, apart from the one where they ask for Gero.
Well, fine. I'm glad we asked this question. All the other cases them where they count, they judge them. If you read the judgments, now different judgments then deliver based on the law and the facts we adduced before the court. Okay. So for me, you go say holistically, for say. But
in the situation where I just want to ask a follow-up question. In a situation where somebody accused somebody of ballot stuffing, rigging the elections, you go expect say there should be a rerun of the election because if the person you go to accuse and say then if the election not so in do because you get people the way they conduct the election because next step been the court right then they'll be part of the people who they accuse. So you'd expect say there should be rerun or the judges and just give them your own.
Lamrana, I just don't tell you. I don't bring one instance of Timbo in case.
Yeah, now you understand Timbo. No, I ask about the other cases because there were cases about where get for do like the one at Duazak. We involve Honorable Siraji. Now, the thing now here is very simple. Okay. You know how the thing's simple? The judiciary or the court is hierarchical in nature. Okay. Where it means say, when you start from the inferior court, if you know say the decision has been taken, we dissatisfied with, the court make them very much simple. They come na high court. If high courts don't take decision, you feel say you dissatisfied, you know, okay with that, you can't appeal. And where Rashid, we see the one make us say he's not been honest to the people of this country. Yes. What I mean by that, he's my brother. What make us say he's not honest? He no say, at that moment, that's not the reasoning of the judge where he decide on that particular and anybody
case.
Can challenge him.
Anybody can challenge, including Lawyer Rashid. What I mean say, you not even the CAM as an officer of the court of law, you not even need for CAM. You begin question that particular judgment where the judge don't deliver. We mean say, if you want to do justice to the people of this country, you for go to court. You know why make you need for go court? For make them go interpret
the judgment.
That particular provision. We mean say, if you go to court of appeal, if Lawyer Rashid grab, you go to court of appeal. Court of appeal, in the reasoning of the judges, if they feel say, what in that judge do, wrong, then they give that judgment. It's simple. Okay. So you see how the beauty of the law.
But the one that we appeal in case, they still say they're not assigning case. So not assigning case.
I might tell you how interesting it is. Now, and then one of them will appeal. Yeah. Then appeal, then they abandon the case.
When I don't assign the case,
No, they don't discharge the case.
Okay.
As we they talk, none of them case them no day before the court because when Rashid know that when they don't strike them out and don't discharge them, for we not see and say a day before the court. Maybe you go the first say a day before the court. But one thing what my family when they listen to this program, they understand is this: the opposition, the main opposition, then win more cases in their favor as compared to the ruling government.
On election petitions.
Election petitions might make instances. Now, the one where they get a Kabbalah, Mabuoka, or then other places them. Then come because judge not been high court judge not been there at that time, and then places them. Now Makeni, Nine and count. SLPP will petition the APC people and they lost the case. So what are we saying? That they tell you, say, nobody, the judiciary is independent, than I just one. Even the other cases in a Potloco, where APC, where SLPP petition APC, the SLPP, where SLPP petition APC, the SLPP lost the case against the APC. So are we not talking about the beauty of those judgments? Where them good ones, when we judge this, where the courts don't do. Now just one thing, no more we go to watch out when them do one within the remit of the law.
As we round up, Elkas, Lawyer Rashid talk about something, the spirit of the response from the judiciary to the EU observer mission. You know, the detonation of it, when I say we don't lost confidence, we don't lost respect and trust in them and all of that. And like you say, we see, I see recently the British High Commissioner visit tonight, it was all over and PR and stuff, and you know, the MCC report as well. But how, you know, do you take in good faith, maybe say recommendation or comments them, if they come up from the same institution they are way, una the praise, so now say they get good relationship with una?
Now, I say this. La Rashid, they make a laugh. Now, I say this, but this is very serious. Famulem, we treat this issue very much seriously. Now, that make AYV create the platform for more we can discuss issues of national development. Now, you see, we use one word when we talk about professional incompetence on the part of the European Union. When the European Union team came for Kange meeting with we, I was in attendance, then tell we the major reason we didn't come for. On then 29 recommendations then. In fact, we start for record the entire, because that's what we do. We archive those things for posterity. You understand? Because we want to be accountable. The Chief Justice say we need to be accountable to the people and do them in a very transparent manner. The EU now then say, now a confidential meeting.
Okay.
Therefore, no all waiting with the discourse, not for go out. So now we stop, we videographer, stop from that moment. Now that even make at the end of the video, we see I'm saying we not report them.
Okay.
Because most of them things then with the report, waiting exactly happen on the report, all sides. So for make you go grab, where you say this is a confidential meeting, you understand? Then you grab, you go talk, things them about the judiciary, where you know bring and come, now been an opportunity.
For them to respond.
Exactly.
Okay.
Not for me, you tell we say more this now confidential meeting.
Okay.
Then you go grab, you go make a press conference. Is that not a professional dishonesty?
Lawyer Rashid,
Yes.
Lawyer Rashid,
Yes.
as we round up the
Yes.
issue of you know, trust in the judiciary, as highlighted by the EU report and all that. How do we build that? You know, we can forget elections. There will definitely be observer mission, but there will always be petitions as well. How do we build trust? I can't just say, well, even as lawyer, when I think say judgment is not okay, when I can take them to the appeals court and get judgment over them.
Yeah, I see him brother cast the sweat.
No,
and the obvious.
if you say at the sweat, everybody the sweat here. Because it's not the you know what you want to do now. You want to talk about
I'm not being dishonest to the blocks. Focus me. Focus on the issues. Now, here is what I am interested in and my organization. We are working with the judiciary. Cass knows here, and the Chief Justice knows.
Yeah, we appreciate
always they can talk with them. You know, raise them and hands up when they need we
exactly.
and things where they do right. And make always not say no. I'm not going to condemn the judiciary as other people are doing. No, there are things they are doing that is right. I will say it, and where they have challenges, I will say it as well. So, I casting name for tell we. So I was waiting for him to point a law where say.
On the explanation.
I was waiting for him to point a law where say. So when they pull that person there. Therefore, you place out to the other person. Now, I am the wait for let tell me. But you say, no, still able to tell me anything. So there's no law that says when you remove a parliamentarian, you must replace it with another person.
Okay, it's saying that the judgments,
now they tell us say so in that's the point.
But you can challenge it. So
yes,
and
I'm not here to talk on their behalf.
No, I'm not saying the APC people, but yourself.
But what I know is that issue was challenged. And he's not going to tell us what was the outcome. He says don't know the matter. But I know parliamentarians who were affected to challenge the issue on appeal. All right, and it took so many months for even it to be assigned. There were so many issues on that.
No.
All right, but that said, now I'm looking at even the precedent that has been set. So that is my concern as a human rights person, because tomorrow any government can come that does not have a majority in parliament and sees an opening and will say, well, for me, I will injunct 50 to get me a majority.
Okay.
And they will be justifiable to do that based on that. I think it's also the judicial precedent.
But not the president do this. It's the judiciary, no?
No, judicial precedent.
Okay, you mean,
all right?
Okay.
Yeah, following what has been decided. All right. So he just mentioned that. So that is why some of us are afraid of what we are seeing. It's not about the convenience of the day.
Okay.
It's about what posterity will mean.
How do we build trust in the judiciary?
Now, defending yourself, sometimes it's not even necessary in the face of an absolute truth, which was exciting a lot of attention even before the EU came.
Okay.
So what's the judiciary on this issue? All right. So let's stop the defense for one. Look at the recommendations, take them in good faith, and see what we can work on. Not to all things what the EU say and that we agree to. In fact, the EU recommend one thing where me personally say no, this one they miss and wrong. For example, let's say we for pull the registrar, the registrar for NCRA, and data. I don't agree with that. They can neck for register you for election. So how do we engage with them and don't be confrontational, abusing them? They were insults in that response. Okay. And to me, that's not how we deal with a partner who has been very helpful to our democracy, to our electionary process, and even to our infrastructural development.
Elkas, finally, how do we build trust in the judiciary?
We must say this.
No, quick, time don't close on we. Time don't close on we.
I remember we at the list in BBC, where I think Asia, some people and do some findings. The people in grab and then they talk say the findings where they do it was not correct. They use the opposition. The waiting the opposition go tell them and they rely on. Okay. So it was everywhere. When they follow, when
so
they
are you saying the opposition and talking?
No, I'm not saying
so
that.
Finally,
so I just say everywhere when you feel say things are going wrong or when institutions they come out with a position.
They can be challenged.
Exactly, like what you say.
But also the EU agree no. In fact, the EU justice will of all reports condemn. I mean, bring you down. Down.
Now,
now,
I say this. Waiting with the focus on now, as an institution or as a judiciary. Now, for able to make sure say, like what we open up, we able to make sure say, we get judge them across every district.
Okay.
That's now we focus.
Okay.
Then able to make sure say. When you talk about the access or expeditious trial, we able to make sure so we enhance her.
Okay.
But even though we talk about access to justice, expeditious trials, we look at the infrastructure. The infrastructure, if you go Lamrana, when we go Kwendu, we go sit Kwendu. Now open court, now they will go sit. The judge, now open court, open side. They are not to court safe. Now they will go sit.
Space.
It's open space.
Okay.
So how do we create or establish the required infrastructure for make sure say the issue of access to justice, expeditious trial may happen in a conducive working environment. These are some of the things then right now what we think about. So now that make we can always call on the government of Sierra Leone for continue for support the judiciary so that we will be able to make the judiciary an envy in Africa.
Thank you very much, Elkas Sano from the Judiciary of Sierra Leone and Lawyer Rashid from Legal Link, and thanks for Unatem, and I'm sure we viewers them don't get some understanding of things that really happen within the judiciary. So we decide for get this discussion so we can understand some of the recent happenings of things that really happen inside the judiciary. Tete will meet back next week. Mina Amadula Mwanaba. Thanks to una viewers them for una don't day with we, and thanks to the technical team and production team as well. Continue for watch AYV for more information, education and entertainment. Hot seats they return next week. Tata.